rise. Court is now in session. The Honorable Scott Suskow presiding.
Thank you. Good morning, everyone. Please have a seat.
Good morning.
All right, so we're here once again on State of Florida versus Sheila Keen Warren, case number 2017 CF 8722. Good morning, Ms. Keen Warren. And counsel, state your appearances, please.
State of Florida, Reed Scott, and Lisa Roberts.
Good morning, both of you.
Good morning, Your Honor. Greg Rosenfeld, Amy Morse, and Jesse Isom on behalf of Sheila Keen Warren.
Good morning to all of you. So we're here on, I know that there was a motion to compel, motion for sanctions that was included with the motion to compel that I granted last week. But additionally, I would also indicate I would rehear arguments regarding the motions I already denied regarding motions to compel. Before we get started with that, I want to ask you, Mr. Rosenfeld, in your motion, the unopposed motion to continue, you indicated that, just find it here, Mr. Scott had found the clown sightings file, a folder, in his office, and Mr. Scott told you that. Can you tell me, can you elaborate on that? Was that indeed the case, sir?
Yes, Judge. So, can I approach the podium?
Yeah.
So after the continuance in May, Ms. Morse and I deposed investigator Tim Valentine, who was not listed by the state. This was the lead investigator in 1991. He was required to be listed, and I'm just giving you some background as to how we get to the box. He was present for 17 interviews. He conducted 3 other interviews. He was present for the interviews of the 4 eyewitnesses. He tried on the clown.
I just want an answer.
Sure, but
Because last week you wrote in, it must have been a conversation that happened last week.
Correct.
Scott's telling you.
but there's a basis.
I'm talking.
Sorry.
Scott's telling you that he found the file in his office. Did that happen or not?
Yes, but
Okay. Now I'll ask Mr. Scott about that in a little bit. Because according to what he wrote, the police had it.
but without background, without giving you the background for it,
It's really not, it shouldn't be complex.
yes, he called me while I was driving to a doctor's
And
appointment.
what did he tell you?
And Mr. Scott said, Mr. Rosenfeld, or Greg, I'm really embarrassed. You know, I'm going to cut right to the chase, Greg. I'm not going to beat around the bush here. We went back and we looked through the file where we found Tim Valentine's case file, which is why I was giving the background on that and where that box was. And we came across the clown setting file. He said, I don't know how I missed it, how Mr. Hoover missed it, how Detective McCann missed it, but we did. And
So if I understand you correctly, Mr. Scott told you he found the clown sightings file in his office, correct?
well, he found
That's
it
what you wrote in your motion.
Yes, he found it in a box that he previously told me and Miss Morse was in his office. Then he told me that day he found it in the same box. And then I said, Mr. Scott, I said, Reed, you got to tell me, is this what's in this clown file? And he's like, it's what you'd expect. I'm so sorry. I made a mistake, which he said over and over again. And then we drove to, I drove to my appointment. We had a deposition, of one of the state had a deposition of one of its experts. And next day, he produces this clown setting file.
I understand that, but again, you wrote in paragraph 8 of your motion, October 12, one day after the hearing, 8 days before her trial, 40 months, blah, 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 the state informed the defense that it found new evidence, the clown signing file. Despite alleging that it did its due diligence in searching for the file, the state admitted that the clown sighting file was located in a box in its office, which means not an office at the sheriff's office, but in his office. He told you that, according to what you're telling me, right?
Yes, he
Okay,
found it in.
all right. I'll find out from Mr. Reed. Mr. Scott, come on up. Can you enlighten the court, please?
I never said that, Judge. I informed Mr. Rosenfeld that Detective McCann located the file. Detective McCann is here present to tell you where she located the file and when she located the file. What I said to Mr. Rosenfeld was we had previously looked for this file specifically, but also when we went looking for Tim Valentine and Paul Moyle and other people's files, we looked through everything. But I explained to him that Detective McCann found the file at the sheriff's office. Okay. That's what was said. And Detective McCann is here to tell the court if she needs to testify where she found the file and how many times she looked for the file. Mr. Hoover was also prepared to testify that he previously looked for the file, but Mr. Hoover is he's out on vacation this week.
I just, listen, a lawyer writes a motion, signs his name to it, okay? Someone's not being forthright with the court. I don't know why Mr. Rosenfeld would tell you that when, I'm sure Mr. Detective McCann would say that she found it in her files, right? I mean, it's not complex stuff. Why would Mr. Scott lie about that?
He told me and Miss Morse later that night on the phone that he found it in the same box as Detective Investigator Valentine's case file, which was a box that he had previously told us was in the state attorney's office.
So possibly you misunderstood Mr. Scott about where the box was located?
Mr. Scott was crystal clear, Judge, and I'll say this, as somebody who's not here on sanctions and has nothing, and every pleading I give, Your Honor, wherever possible, I file 80-page exhibits. And I do that because I know the state's going to come in here, give some blanket statement in their 5-page response, not supported by evidence, and get up here like they did at the last hearing and say, Judge, we did our due diligence. I spend an ungodly amount of time on those exhibits, so the record is crystal clear that everything I'm representing to this court is accurate. And for someone, again, who's not here for sanctions, if you want to swear me in.
You both are officers of the court. I don't need to swear you guys in. You're supposed to tell me the truth. You're right. When you sign off on a motion, that's you're acknowledging what you claim is the truth. So I guess I'm not really going to get down to the bottom of what was really the content of Mr. Scott's conversation with you. And we need to move on with this case, but it was written in a motion that I relied upon in making my ruling, right? That Mr. Scott found it in his office, which would be ridiculous if he didn't see that in his own office, right? File that he's been working on. So I don't want to spend too much time on that issue, but it seems like Mr. Scott, and I'm sure that you would proffer to me that the detective would say that if she found it in her in the odometer file of the Mr. Warren, right?
And she's prepared to testify under oath.
Which, by the way, is ridiculous that she didn't find it exercising due diligence when I'm sure, Mr. Scott, I would hope that you have been telling her repeatedly, find the file, right?
Yes, sir.
Okay. All right.
And Your Honor, if I could briefly respond to that last comment you made.
Yeah.
In my initial motion about the clown setting file, again, to provide the court with evidentiary support in advance, I attached Deputy McCann's first deposition in 2019 and May of 2022, where she claims she still did absolutely nothing to look for it. She didn't ask anybody about it and completely disregarded it. And the passage is in the motion and the transcript is attached to the motion.
Okay.
And then suddenly, out of the blue, when the court threatens the state with, or pardon me, when I file this Brady motion, which the court initially denied, then Detective McCann decides to go and look through, after 4 years of us asking, and after the court denying my request, then suddenly she decides to go through boxes in other cases. I mean, it defies logic. It defies the pattern that is.
What do you think? What do you think happened to the clown siding file, Mr. Rosenfeld?
What do I think?
Yeah.
I think the same thing that happened to, and that's why I was trying to give you some background, because it explains what happened to the clown setting file. It wasn't to waste this court's time. I know this court has incredibly busy docket, but it was to give some background as to what this repeated pattern of discovery violations that have happened recently after the last trial setting. So as I mentioned, we deposed this unlisted investigator who, without question, pursuant to 3.220, they should have listed. He shows up and he tells Ms. Morris conducted the deposition, I was there, and he says, oh, I have reports in the office in my case file, which was never turned over. We reset the depot. We file a demand for specific discovery, requesting the reports. Mr. Scott turns over a case file that's been in their possession, that's been in this box, that they didn't see. In that case file, among other things, was notes about another witness from the clown sighting, from the costume store, who provides the basis for a motion to suppress, who indicates they've been gossiping about this for a year, collecting articles.
Mr. Roosevelt, I've heard enough. Have a seat. We're going to go through these motions one by one. Okay? I just wanted, all I wanted to do was get some clarity, I don't know if I really got it, as to the conversation between you and Mr. Scott. Lawyers, when they talk to each other, should be forthright with each other. I'm never going to, get down to what, it wasn't on tape, right? So I'm relying upon good lawyers to tell me or make representations as to what happened. Mr. Scott says he never told you that. You would have told him that it was the police had it, right?
I told him Detective McCann found the file.
Okay, and you deny that, right? Correct, Mr. Roosevelt?
I deny that, and
okay, then, but we need to move on. Got to move on. We got a lot of other stuff on my plate today. Let's move on. Have a seat, both of you. We're going to take things. Actually, we might as well stay up there because we got to deal with all these different motions. So, all right. So I'm asked to reconsider the different motions to compel. Let's do that. Let's start off with second motion to compel state to produce Brady information.
And Your Honor received all my responses,
I did.
correct? Okay, thank you.
Yeah. What else would you like to add as to why I should reconsider my previous ruling, Mr. Rosenfeld? As to your second motion to compel the state to produce Brady information.
well, I guess the first thing I'll say is the state, having been ordered to come here for purposes of sanctions, I would think at the very least they would file responses or pleadings that are factually correct. And even looking at the fact section in its motion has a number of misstatements, which I pointed out at the bond motion, which isn't supported by their evidence, which I'm, again, frankly shocked. And
So deal with the sanctions issue at the end. So let's just deal with this particular motion.
oh, I am. I'm going
You
through the
tell me about
facts.
your shock later, okay? Please just focus on this particular motion. Add whatever you'd like to add at this point in time as to why I should reconsider and grant your request, okay? Please do so.
I'm going through the facts in their motion, in this second motion
Go
to
ahead.
compel. So first, they make allegations that the witnesses all describe the shooter to have man-like features. That's incorrect. 3 of the 4 said it was a man. That's a misstatement. Next, several
Are
witnesses.
you arguing your case to a jury right now, Mr. Roosevelt, or to me as to requesting more information from Mr. Scott?
I'm responding to the facts in the pleading.
I know the facts. Okay, I'm aware of the allegations. I've sat through a bond hearing for a full day last year. I know what your points are. Please tell me why I should reconsider my ruling, sir, and not regurgitate what you've already told me in the past or what you've written in the past. Just focus, okay?
One moment, Judge.
Okay.
All right, first, and the defendant, pardon me, the portion that says the defense request. The state points out that prior to filing its motion, counsel for the defendant and Erdy obtained a copy of the audit report and other documents. Not from the state. We actually had a anonymous person send this to us in the midst of our case, saying this is problematic, this audit report exists. So the state never turned this over. Then the state, again, as they do in every single response, gives this and this is on the second to last page, a list of all of these things that it claims it's done. Now, these are things we've asked the state to do for 4 years. And then suddenly, after, again, us being called in here to court and the case being continued in the past week, the state looks into these things. Why it takes 4 years in the court ordering the state in here to do the things it's alleged in this motion, and doesn't indicate that it has recently done since the last court date, is egregious. I mean, it defies logic, and it just allows the state to continue to do this unless called into court by Your Honor and threatened, because they're not held accountable. First statement: the state has searched its files and does not possess any documents related to the internal audit report. Well, again, Mr. Scott wants us to believe, without any evidence, without any exhibits, anything, that statement's true. We should take his word for it.
Well, do you have any evidence to the contrary?
Yes.
He's got the audit report?
A repeated pattern of discovery violations in this case, in other cases.
So you're speculating that he's got it somewhere, or he should have it somewhere, right? Tell me where it is that you think he's got it, and he's hiding that for some reason. Where is it?
The state has an obligation under the United States Supreme Court to look for this information. Not just, is it in my file, do I have to turn it over?
So they indicate what they did to try to get it, right? What else do you have to show that this is not true?
What they've done in the past week, after Your Honor granted a continuance, after we've requested this material, after we've deposed Barry Krischer, after we've deposed Mike Edmondson, after we have exhausted extensive funds investigating this and trying to track down people from this audit. This isn't, the state's making this representation here like it's done all of this work and it's been complying with its Brady obligations. This is stuff that's done in the past week. In the past week, in 4 years of asking them this for this material. And let's not forget, when we talk about the severity of this was a death penalty case for 2.5 years before Your Honor took it over. This is a death case. And it takes you ordering the state in here with their boss, with the elected state attorney, to do this simple work. They say that Detective Paige McCann, and to give you a idea of how just outrageous what they're saying and what they're alleging here is, the state inquired with Detective Paige McCann and Sergeant Richard McAfee at the Palm Beach County Sheriff's Office, and neither one possessed any records relating to the internal audit report. Now, May 2020, in my motion, in a sworn deposition from 2019 and May 2022, we asked her, we've told you about this audit report. Have you done anything to look for it? No. Have you asked anybody to look for it? No. I mean, this audit report is so crucial to our case. And again, she does nothing. And then the state comes in here and says it's complied with this Brady obligation for...
It's a discovery request, right?
What?
That's what you're asking for here. You're making a conclusion that this is Brady, that this is exculpatory information you're asking for. Absolutely exculpatory, right?
I have a good faith basis, yes.
Okay, all right. So I would assume Mr. Scott would disagree with you in terms of the position that this is actually exculpatory, correct? You may argue it down the road that it's exculpatory. That's your position, that it's potentially Brady material, right? You don't know it for sure. Do you know for sure that they had an audit in the sheriff's office?
Yeah, we have the audit.
Do you know that's actually Brady material?
Yes.
Tell me how it's exculpatory.
We have statements from Mike Edmondson, which don't even get me into that deposition, but statements in the report, not in the report, in the newspaper article that he gave, which indicates that open bags of evidence were found in this case, right? These bags of evidence are, again, crucial to why they reopened this case. And then we took sworn testimony of Detective Harrison, who the state struck. And yes, that is an exculpatory witness.
Okay. What else you want to tell me, Mr. Rosenfeld?
What files did it search? It searched its files? What effort did it make? I mean, the state just gets up here and says, we searched its files. It said it represented to the court last week that it did its due diligence. At that time, it had not searched its files. It had not done anything here. And let's call it Brady or discovery, regardless of what it is. They didn't do it, and now they're saying, oh, we did it now.
Mr. Scott, when was this done?
Well, I had searched my files, the entire files that were in my office. That includes the investigative file, my trial file, the digital file, the evidence file. I had done evidence views, and I had asked Detective Paige McCann if she had any of the audit materials because I had never seen.
When did that happen?
Oh, that happened. That's happened a long time ago.
It wasn't last week?
No, I went further last week because I wanted to ensure. So I said, Detective McCann, do you have a copy in your file? Because it seemed like what defense counsel was requesting was anything in Detective McCann's personal file. Defense counsel provided a letter from the county auditor that would indicate that files are purged 5 years after publishing of the report, which would have made it 2004. So I said, can you please put me in contact with Detective McAfee, so who I had contacted. And then Detective McCann reached out to the evidence coordinator, Mary Lou Doss. Ms. Doss indicated that she never even had the original 99 audit report, but then Ms. Doss, went and indicated she didn't have anything further. I talked to Sergeant McAfee, and I apologize if I said lieutenant in here somewhere. He's a sergeant, and asked him to check with anybody who would have handled the audits or grants prior to his handling of that, and indicated that he had consulted with Jim Davis and Corporal John Preschel, I think he was a former CFO, Jim Davis, of the Palm Beach County Sheriff's Office, and neither one of them had any of the records pursuant to this audit. So given the county's letter that it would have purged any records in 2004, and I've consulted with multiple sources about anything about this audit, I don't know where else to turn to find the audit. I've certainly never seen anything, and these ladies and gentlemen have nothing to give to me.
Okay. Anything else, Mr. Rosenfeld?
I don't think he said, if I misheard, you asked when.
He said that it happened last week and before. They followed up again last week. If I understood it correctly. Anyway, what's your response, Mr. Rosenfeld?
So
Anything else you want to add?
Yeah, he followed up last week after the trial was continued. And again, May 2nd, 2022, deposition of Detective Paige McCann.
So you wouldn't want him to get, what you're suggesting that he shouldn't even asked again last week? What you're telling me?
Of course he should, but the state can't come in here and say, well, Judge, we didn't
Mr.
do...
Roosevelt, what else do you want to add to your argument as it relates to this particular request?
I'm trying to add to the argument. The state's coming in here and saying, all right, Judge, well, we didn't disclose this, we didn't fulfill our obligations, but now that trial's continued, now that you've spent over $3,000, now we've looked for it after the fact, despite 4 years of asking for it. That's not complying with their obligations, Judge. And it just baffles me again that in a case where death was sought, where they wanted to execute this woman.
Keep going there, sir. Just focus on your argument, sir. I understand when you told me about this was originally being a death case, and it's a serious case. I understand that. What else do you want to tell me as to why I should agree with your request?
Because speaking to the Internal Audit Committee, that's not our request. Our request is that Mr. Scott speak with, do a diligent search into PBSO, do a diligent search into his office, and that diligent search, again, which, on our end, we tried to do through deposing Mike Edmondson and Barry Krischer in one of the most, at least Mr. Edmondson's depositions, one of the most disturbing and deceitful depositions, which was attended by Mr. Scott, Mr. Johnson, Ms. Miller, where he made any and every statement indicating that he's done nothing, or that he may have been misquoted, or despite there being, then me looking into it, there being no corrections, no retractions, in a case, in a statement he made, where the evidence unit was missing over $100,000 from a case, where purportedly evidence bags in this case were found open, and they did nothing. So if the state's position is, or comments like, oh, I have no idea what Mr. Krischer's up to these days, when Mr. Krischer's deposition clearly shows otherwise, if the state's position is in a homicide, or in any case, misdemeanor or a homicide, members of its office can get up there in a deposition and do anything and everything possible to avoid answering questions about, if you want to call it potentially exculpatory, and that seems to be your position based on the questions you asked. That's incredibly disturbing, especially in a situation where the state attorney's office and, Mr. Ehrenberg have a conviction integrity unit. Our requests throughout, the evidence we are seeking, are the reason why they have conviction integrity units. And, you don't want me to rehash my pleadings, but
So I've read them, sir, and I've given you time to have your matters reheard, okay? So just if you can be respectful of my time as well, Mr. Rosenfeld, what else do you want to tell me that I haven't heard before to reconsider my ruling?
that the state did not comply with its discovery obligations until after being ordered into court, after representing to the court that it did its due diligence, which, having done all this work after representing that, it clearly did not do. And, we can address, the state's interpretation of Brady later when we get to that, because that's not what Your Honor's asking at this point.
I'm just giving you time, giving you the opportunity, in light of what you told me last week, that they had found this file in their office, to re-argue some of your motions today. This is what I'm letting you do. Is there anything else you wanted to add as to the second motion?
No, Your Honor.
Okay, let's go to the third motion. Third motion to compel. I've got the state's response. What would you like to add to that, Mr. Roosevelt?
One moment, Judge. The state's position as to the clown setting file clearly differs from what it was last week. And clearly differs from, again, aside from what Mr. Scott and I are going to disagree on, differs in terms of the severity in a lengthy conversation on the phone he had later that night with me and Ms. Morse, he represented. Mr. Scott's position
Just before we get started, can we bring Detective McCann up here, please?
You want her to the left or the right, Judge?
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Good morning.
Good morning.
Tell me your name and spell it, please.
Paige McCann, P-A-I-G-E-M-C-C-A-N-N.
Just want to ask you something, just to I want to narrow this down as much as possible. Did you find the quote-unquote clown sightings file?
Yes, Your Honor.
Where did you find it?
In a file within my office.
Okay. And what file was that?
I have three big banker box files for this case. One has all witnesses, the second one is documents, and the third one pretty much relates to miscellaneous things such as Michael Warren's, where he had been arrested for the odometer tampering. And that is the file I found it in, or the box.
And what day did you find that?
Your Honor, I think it was Tuesday or Wednesday of last week.
So would it be fair to say that the file was not found in Mr. Scott's office, but it was in your office?
Correct.
Thank you. You may have a seat. Go ahead, Mr. Roosevelt.
All right, so the state's position in this motion, just looking at my notes on my
I
phone.
don't understand. Why would he tell you that he found it in his office? Why would he do that?
Why would he misrepresent for 10 months?
What benefit is that? If she found it, what did he have to gain by making such a misrepresentation to you, Mr. Roosevelt?
There's been multiple misrepresentations we don't understand.
Tell me, why would he lie about that?
Because he did it in the past in other cases, the same thing.
What benefit does he have to lie about that? What's the benefit?
That's what the defense bar is wondering. Since this happened, since last week, I've had defense attorneys in the community reach out to me in cases, and you can speak to your colleagues about this.
Mr. Roosevelt, as it relates to this particular issue, what benefit does the state gain by misleading you as to where the file was found? What was he going to have? You almost have to assume that this detective was in part of some conspiracy with Mr. and come up here and lie about the fact that she found it in her own office.
Oh,
What
that's
sense does
exactly
that
what
make?
we think. We think one of two things happened. We think either, not we think, clearly one of two things have happened. Either they're lying, which, again, swear me in. I'd be happy to ask what Ms. Morris as to what we know. Or PBSO's evidence unit is such a mess that they're finding evidence in other boxes in its evidence unit the week before trial, and who else knows what other evidence is in these other boxes in other cases. Those are the only...
It's a big allegation you make against Mr. Scott, that he's coming in here and lying about where the file was found, Mr. Rowe. I still don't understand what he would gain from that.
He's alleging that I'm lying in his pleading.
I just don't understand why. What would he have? What purpose would he have to? Let's assume he was some nefarious prosecutor, right? Which, by the way, I had cases with Mr. Scott when I used to be a defense attorney, and his reputation was impeccable from where I sat. I had cases against him. I found him to be forthright, sir. You can tell me about other people that have said certain things. I have found nothing but Mr. Scott to be forthright, honest, and ethical in his dealings with me when I was a defense attorney. So you may come here and tell me that some other lawyers are going to say some bad stuff about Mr. Scott. I'm just telling you from my own personal experience what I found. All right, now you're telling me that he is lying to the court, which is a big move, lying about this statement to you. I wasn't there for the conversation. It certainly wasn't tape recorded. But I still don't understand what benefit he would have to lie to you about where the file was found. Tell me what the benefit would be to him, even if he was a nefarious guy.
What benefit would I have from lying?
What benefit would he? Tell me what benefit. Answer my question. What's the benefit to him? How does he gain from that?
He got called out for sanction, and he's covering his tracks at
So
this
he would
point.
bring McCann on his little conspiracy then? That's what you're saying, Mr. Roosevelt?
So are you suggesting that me and Ms. Morse are part of a conspiracy?
Maybe you all misunderstood the conversation. Maybe it really wasn't delved into enough during the course of the content of the meeting. But I just don't understand what benefit he had. We need to move on here, sir. But it's a heck of an allegation to state that he's lying about it. I don't understand what the benefit was. You still haven't told me that. What does he have to gain?
I did answer Your Honor's question, covering his tracks after gross misconduct. And the same, but again, what benefit do we have?
Maybe you misunderstood what he said. I don't know. But then go ahead with your arguments.
And respectfully, Judge, you just made a comment that you've had cases against Mr. Scott.
I did.
And you expressed your opinion, but
You expressed your position about that. You've got some other folks or colleagues of yours saying that Mr. Scott has withheld information or whatever. I don't know what you said anymore, but it wasn't positive, right? Correct? You said something negative about some other people that would say to you or have said to you stuff that's negative about Mr. Scott, correct?
not negative in reputation. I'm talking about recent homicides where the same conduct has happened.
All right.
And
we need to move on, Mr. Roosevelt. Okay. Let's continue with these motions.
But
Make your arguments.
I mean, respectfully, Judge, my concern is if you're, and I bring up the fact that you're making these comments that Mr. Scott, you've worked against him in your career.
Like I've seen you and Ms. Morse's litigated cases for me, I have no reason to doubt your reputation, sir, either. Okay? And like I have no reason to doubt Mr. Scott's reputation. You came in here basically and you slandered Mr. Scott a moment ago by telling me what other people and colleagues of yours would say some negative stuff about Mr. Scott. I've never heard that kind of information before. And all I can tell you is from my own personal experience, Mr. Rosenfeld, I've never seen Mr. Scott do anything unethical.
I'm not.
Okay?
I'm
So
not saying
please continue with your motion. I'm going to give you 5 more minutes to finish up your argument. We've gone off on this tangent. I want you to focus on this particular motion. You've already argued in front of me a couple weeks ago. Please add whatever else you would like to this right now, sir.
Sure, and I'm not arguing that I brought people here to bash his character.
Again,
I have to
I'm going to
establish.
give you 5 more minutes. Argue this particular motion, sir,
I
again.
have to establish negligence versus willfulness.
Okay?
In order to establish willfulness, I can establish a pattern of conduct that shows it's not negligent. I'm not basing this on what people are telling me about Mr. Scott. I'm basing this on discovery violations that your colleagues found recently and ruled on in homicides. That's not a attack on Mr. Scott's character or bringing Mr. Scott in here. It's me establishing willfulness. And I'm simply asking for the court to permit me to mention those cases. And you can ask Mr. Scott about it. I'm confident.
So you know what you can do? You can supplement your argument with any written rulings that you have from colleagues of mine that are
Sure.
consistent with your position, okay?
All right, so essentially, well, a few things as it pertains to this motion and, all of Mr. Scott's pleadings as to the motions to compel. He's not in the wrong because his office spent the past week trying to find this information right before trial that we've asked for years. He also makes comments in these motions that he's not committing discovery and/or Brady violations because the evidence may not be admissible at trial. That's also not the law. Discovery violations have nothing to do with admissibility at trial. He also makes comments in his motions that, okay, I committed discovery violations essentially, but it's not a big deal because we don't find the evidence important to our case. We find it to be trivial. Now, the comments about the clown sighting file. He says that we said it was credible, and now that he had further time to look into it. And again, that's not representations he made to defense counsel or to the court, for that matter. He never said then he didn't have time to look into it. He indicated to Ms. Morse and myself that it was serious and a big deal. His position in these motions is that these are not discovery violations, not because he looked into it, because presumably either his investigator or Detective McCann investigated this in the past week. He indicates in his motion that 11 of the individuals were determined to be deceased. So when and by whom? Where's that evidence? And what does that matter? The fact that somebody's deceased doesn't mean we can't investigate a case and find more information. Are they going to let us know who these people are who were deceased? Which witnesses?
Well, that's why the case is continued for you guys to start fleshing all that out, right?
Your Honor, may I just on that point?
Yeah.
I have a report prepared to turn over to defense with all the investigative work. So
Right.
we've done all the work for them, and they have all the names, dates of birth, dates of death, contact points, anybody that we can find, all the work that's been done on the clown sighting file.
Okay.
So I just turned that over to defense.
All right.
After trial was continued for something that was either, regardless of which you believe, in their constructive or actual possession. But represent that only 1 or 2 contain information that was in some way similar with the facts of this case. No, similar with their facts of this case, not our theory of this case. They neglect to mention in their motion that one of the people one of the tips, and I believe with that one, there is a name and a phone number. Indicated that I saw a white male named Keen, a picture, that would be Richard Keen, who has been a suspect in this case, buying balloons from Publix on May 20th, 6 days before the shooting, the exact balloons. That's, I'd say, a pretty big fact, and something that very well would or could lead to reversal had this gone to trial then, and
Which is why the case continues. You're gonna look into that stuff, Mr. Rosenfeld, okay? So go ahead, yeah, now we're talking about the federal grant and Ed Barr. What else you wanna tell me about that? Again, I've already heard this motion. I already denied it. Tell me what else is you'd like to re-argue it along these lines, sir. Anything else?
well, I mean, yes, Your Honor, you're saying you denied a motion, a Brady motion, now they're turning over the material.
We're talking about the third motion to compel, sir, which wasn't just the and you keep saying Brady material. I mean, you know that those people are gonna exculpate your client?
Well, Brady doesn't require
Or tend to exculpate? You're talking about, I mean, isn't it consistent with most cases that the police are gonna go out and look for suspects if they don't have a person, right? And that's, a lot of these people are probably suspects, correct? Right, Mr. Rosenfeld?
Yes,
So how do you know that any of those people are absolutely gonna exculpate your client?
that's not Brady. Brady doesn't require this.
Again, let's focus on, what else do you wanna tell me about the federal grant and Ed Barr, okay? That you haven't told me already previously.
May I respond to Your Honor's comment?
No, I want you to focus on my two questions to you, because I've given you more time to re-argue your motions to compel, which I've already denied. What else do you want to tell me, Mr. Roosevelt?
All right, well, as to the federal grant, Ed Barr, and the ongoing investigation, Brady does not require for all three of these that the evidence exculpate. It could assist in Ms. Keen Warren's defense. That would also be Brady. The federal grant, they're saying that defense counsel has inquired into it, and it's been destroyed after 5 years. I find it to be disconcerting that Detective McCann, in a case where she sent out DNA as part of this grant to the FBI, has no knowledge of how much this grant was. I mean, she could very well follow up with the people who provided this grant. It's not hard for them to do. We did everything we could do. We're just asking that they do what they're required to do. Ed Barr. The state represents the sole evidence that Barr had anything to do with the murder of Marlene Warren rests with the statement of an inmate named Jeff Libby. That's not true. And this is the importance of Ed Barr. Ed Barr, when Detective Bill Williams flew up to Maine, and this isn't to Jeff Libby, this is to Detective Williams, to PBSO, said, if I tell you what I did, will I get the electric chair? Not mentioned in their motion, and that's important because that's not a statement made to a jailhouse snitch. That's a statement made to the lead detective in a homicide. They also fail to mention here that the two guards. Then when they get down to the two guards, they say they contacted the Maine State Correctional Institution, but these guards didn't work at the Maine State Correctional Institution. Per their reports, they worked at the Cumberland County Jail. So if their due diligence a week before trial is calling the wrong prison and not contacting the jail, or with their immense resources, not being able to find these two people they should have listed from the beginning, Ed Barr, Jeff Libby, Heidi Bigelow, Shirley Corbin, that's problematic. And we still don't think they've complied with their Brady obligations under, their Brady obligations to seek out this information. They indicate that Detective McCann hasn't saved the jail calls that Ed Barr made. There's no reason why she can't make a disc of the jail calls.
Mr. Scott, about the jail calls, what else can you tell me about that? I mean,
There's an ability for detectives to listen to jail calls live without requesting a disc, and Detective McCann did that, and believe answered questions to those effect in the deposition, but you don't necessarily have to order a disc. If you don't order a disc, the calls are purged within 1 year. Detective McCann did not order a disc. These calls would have taken place well over a year ago because there is no disc that was ordered, and she only listened live to them. The disc was purged. So Detective McCann can answer questions about anything that Ed Barr said on a call, but there is no disc presently.
So would it be fair to say what you're making representation to, Mr. Scott, is that it is physically impossible to retrieve the information about those jail calls because they're gone?
Yes, and I've spoken many times to Marie Kasplayach, who runs the communication center, and after 1 year, calls are purged.
All right, we'll accept that representation as to the jail calls. Obviously not as to not listing all these witnesses who should have been listed. Now, the state points out that the investigative procedures is work product. And, you know, if I could just pull up, you know, and we mentioned this in our first Brady request in 2018, or Mr. Lubin did at that time. Case law we've told them about, they're aware of, Johnson v. Butterworth, Brady trumps work product. So you can't hide behind work product to not disclose exculpatory information. The Florida Supreme, I mean, this is well settled by the Florida Supreme Court. And they make that allegation as to .42, the ongoing investigation. They indicate that, well, we sent out Ed Barr's fingerprints for further comparison, but we're not going to tell you why, because it's work product. If they're still investigating another suspect in a case,
Suspect who happens to be married to your client, right?
no, I'm referring to Ed Barr first, sending out his fingerprints in the middle and not disclosing that to us.
Okay.
One, they're required to tell us that, but to argue that they're not required to tell us why, especially in a deposition, those fingerprints are being sent out, why this suspect is still being investigated, even if it is work product, again, is trumped by Brady. Clear case law. Then the ongoing investigation, D. They say that, they indicate that Mike Warren, their theory is that he acted as a principal. And that's their theory in this case, that's pretty clear. It's part of their theory of prosecution, and they're acknowledging that, there's no dispute as to that. So how can we mount a defense or present a defense against their theory of prosecution that Mike Warren was involved in the murder of Marlene Warren, and then say they don't have to disclose the evidence as to Mike Warren? I mean, our hands are tied. And once again, they say work product, but work product, Brady trumps work product. And even so, you know, Ms. Keen Warren's right to a fair trial, right to present a defense, they can't hide behind work product. So that would be our position as to point D. And the one last thing I'll say is they make comments about opinion of a detective as to why individual prints are sent to be compared is irrelevant. Admissibility has nothing to do with discovery obligations, and what the state finds to be trivial or relevant, again, has nothing to do with their discovery violations. Very often, as your Honor is well aware, things that the state finds to be trivial turn out to be incredibly important for our defense. So those are the points I would make to the state's third motion to compel.
All right, anything else you want to add, Mr. Scott, to your response?
Yes, 2 concise points. I believe when counsel spoke, he spoke mentioning the federal grant and its perjury his perjured documents after 5 years. That was with respect to the audit, so I just want to clarify the record on that. With respect to the federal grant, previously the state asked Detective McCann if she had any materials. She did not, and if any grant money was spent on this case, and she said that it did not. What I did was went again to Sergeant McAfee and supplemented yesterday council with a spreadsheet of all monies that were spent on the 2020 grant so that they could see that it didn't include this case. So I just wanted to clarify the record on that. And then just one more concise point with respect to the opinion as to why fingerprints were sent out. I mentioned in my motion that it's, any opinions of the detective or really anybody as to why something is done is irrelevant. It would be improper for a detective to take the stand and say, my opinion is he had nothing to do with this, and that's why we sent the prints out. So the fact is they were sent out, they were compared, and there's a report. That's what's relevant. So just those two concise points.
All right. All right, so let's turn then to fourth motion, compel.
Your Honor, I don't believe we heard the fourth
We
motion
didn't.
previously, yes.
Go ahead, Mr. Rosenthal.
The first thing I'll say is I do apologize as it pertains to this to Mr. Scott. Because we did have a subsequent conversation, and again, I'll be the first to admit if there is any inaccuracy. He clarified one thing about, and this doesn't go to the remedies we were requesting, but about the initial discovery and the moment Mr. Scott pointed out where this file was. We had two copies of it. It was in one, not the other. Who knows why? I'm gonna write it off to a copying error, as Mr. Scott mentioned on the phone, and I immediately amended the motion to indicate that, that oversight. So, but regardless, that doesn't go to the remedies we were requesting. The remedies we were requesting, and Mr. Scott has now provided part of the remedy, but, which is, I guess he indicates that there's open access to that report, but some of the people involved in this report that's now on the cover of every FBI trace evidence investigation that involved these people, some of these people, as it turns out, were involved in the initial forensic evaluation of the evidence in this case. So, the FBI, the state's in constructive possession, FBI's law enforcement of anything they know, we believe has an affirmative obligation to seek out information as it pertains to these witnesses who were engaged in such a level of misconduct that the FBI recognized. This isn't my position on the misconduct. It's the FBI, Department of Justice's, that they put this at the cover or the front of every trace evidence report from worked on by these, I think it was 13 people.
All right. Anything else?
As to the fourth.
All right. Anything else, Mr. Scott?
No, sir.
All right.
And if I may have one moment to confer with Ms. Morse?
Sure. Motion for sanctions, you ready? Proceed.
So I assume we're doing the sanctions and bond separately?
Yeah. Yes.
You asking me to start or Mr. Scott to?
Well, your motion for sanctions, right?
Sure. All right, well, as I said before, and I'm only bringing this up because it's, clearly heightened due process when you're dealing with a initial death penalty case. And even so, she was subjected to repeated discovery violations throughout this case, starting from December of 2018. I looked back at the state's witness list from 2018, where, essentially between 20 and 30 witnesses were listed as addresses to be provided, addresses that were old, or people just listed care of the state attorney's office. And our position in regard to sanctions, as in regard to this discovery violations, and I'm not gonna speak in hyperbole, it's based on facts. It's based on everything I provided the court with. It's based on what we view as a blatant disregard for the law and the Constitution. The state thinks that it can, based on what we see in the motion, do whatever it wants and not be held accountable. The most troubling thing I find in the state's motion is its interpretation
Your
of,
motion.
or the state's response, pardon me, Judge, state's pleading, is the state's interpretation of Brady. The state has consistently, both in this case, to Ms. Morrison, myself, and Mr. Lubin, indicated that Brady is a post-conviction remedy. And that's their argument. There's no Brady violation because it's a post-conviction remedy. And they're basing this on the standard for Brady in post-conviction cases. And this is outright wrong, and this is outright troubling. I mean, this is troubling because this is the chief of homicide. This is an office that has a conviction integrity unit, and they don't know Brady. Now, 2020, Congress essentially codified, but enacted the Due Process Protection Act, and the purpose of which was...
So this motion for sanctions really should focus on your claim that he told you that he had the file in his office and he was basically willful and didn't share that with you. That's why I sent this so quickly, sir, because it's delayed you said $3,000 seeking costs for that, right? Okay, that's really what I want to focus on today, Mr. Rosenfeld, is your accusation that this is in your claim, because to get sanctions you have to establish this is a willful violation, correct? His conduct was willful, right? And by the way, you should look at the cases of State versus ZA 195 Southern 3rd 1189, and also State versus Nelson 27 Southern 3rd 758. I'm not even sure the court, even if the court were to deem Mr. Scott's actions or inactions to be willful, that I can even tax costs under those cases, which doesn't make a lot of sense to me, because how can you hold the government responsible in situations like you're claiming, where they're withholding information, right? How do you assign, or how do you remedy? How do you get a remedy? How do you rectify misconduct on the part of the state attorney's office if they are indeed withholding information or being grossly negligent and not supplying information? But anyway, those cases would speak to that, I think, to some. I don't know if you're aware of those cases. But so my concern is also whether, even if I were to agree with you, whether I have the ability to impose that sanction that you're seeking. You understand what I'm saying, Mr. Rosenfeld?
Yes, Your Honor.
Okay. All right. Maybe you have case law which would differ than that, and you can enlighten me with that if you have that with you.
Our position, and I'm not aware of those cases, is that under 3.220, this court does have broad discretion in imposing sanctions.
Do you have any case law that would support a similar scenario where in the past there's been a prosecutor or a state attorney's office that's either was grossly negligent or withheld information willfully, and it delayed, it caused problem for the defense, it caused the defense incurred great expense, and then the appellate court upheld a motion for sanctions in the past, sir? Because I certainly would like to see that if you have one. Certainly,
Yes.
certainly it should be the case, right? It should be the case that there should be some type of remedy for a state attorney's office or a prosecutor that withholds information, that leads to a delay or is grossly negligent, and that causes the defense harm, and that it delays the actual day in court, you know? But so if you've got that stuff, let me see it. Do you have those cases?
Do I have an actual, I have persuasive authority. I
What do
don't
you got?
have actual authority. I don't, pardon me, I don't have a Florida case, I have persuasive authority. And that's why I was bringing up the Due Process Protection Act, which speaks to,
Do you have any cases in Florida, sir, which would give me some guidance to seek the redress that the relief that you're asking for?
I would argue that Your Honor can, in a situation like this where Your Honor recognizes that it is somewhat bizarre, that the court can impose financial sanctions in a situation where,
Well, just tell me what, because I see it differently from what the appellate courts have told me and other judges, right, in similar scenarios where it was, the courts were wrong in imposing taxing costs, okay? That's why I want to know if you've got something for me which would tell me that I have the authority to tax costs and sanction the state in a way you'd like me to sanction them.
I can think of one case in the 15th Judicial Circuit, and, you know, the state's, I'm sure, you know, Mr. Ehrenberg's aware of this case, where in a criminal case, the court has imposed financial sanctions on the state. And that was a case with Mr. Gershman and DVTD, where based on state's conduct, and I'm not gonna go further than saying state's conduct because I don't know the specific facts, but I know that the court did impose attorney fees and sanction them financially. So,
I mean, if you have some documents that would support that, then
sure, I
I'd
can
be
file,
happy
and,
to see that.
I mean, I can find more information on that and provide that. So it's not an out of the ordinary request. But I think, you know, as always, in a situation where, you know, as Your Honor pointed out, you know, it seems somewhat bizarre that it's a remedy you can't impose, or.
Listen, the Brady issue is, you know, the state's supposed to turn over what they have that is exculpatory or tends to be exculpatory. It's not an option, right, Mr. Scott? You realize that, sir? It's not an option, it's not a suggestion, it's a requirement.
Yes, sir.
I have in the past, when I was defense counsel, filed motions for Brady. I shouldn't have had to, because it's a continuing obligation on the part of the government, whose job is to uphold justice, to turn over what they got that either is exculpatory or tends to be exculpatory. You recognize that, Mr. Scott?
Yes, sir.
Anyway, I've kind of gone off on a tangent, but that's certainly shouldn't be a matter of dispute or not recognizable as a requirement and an obligation on the part of the government, whose job is to not seek convictions, but rather to ensure that in the end justice is served.
Yes, sir.
All right? But go ahead, Mr. Rosenfeld.
And
But again, Mr. Rosenfeld, I turn back to I don't even know if I have the authority to grant the requested, assuming I would find that Mr. Scott's actions were willful, which I think believe is the burden you'd probably have to meet, sir. But let's even say gross negligence, for instance.
I would make two
Just
points.
tell me what you got to lend support to that position, sir.
You know, I would make 2 points, and again, this is persuasive authority. And that's why I bring up the Due Process Protections Act. Because, you know, the case law changes. And, you know, the Due Process Protection Act, which, as Your Honor is well aware, was codified in 2020 by Congress. And the reason being, they were fed up that prosecutors did not recognize and did not comply with their Brady obligations, and it essentially led to the federal rules of criminal procedure being modified to require district court judges in every federal criminal case in the country to issue a standing order. And that standing order, I believe, and this is the argument I would make, is persuasive authority. And, you know, this also goes to this post-conviction argument the state makes. But, and I'm just gonna read one standing order I pulled from a case I have in the Middle District from, Chief Judge Timothy Corrigan. Pursuant to the Due Process Protections Act, the court confirms the United States' obligation to produce all exculpatory evidence to the defendant pursuant to Brady v. Maryland and its progeny, and orders the United States to do so. Failing to do so in a timely manner may result in consequences, including exclusions of evidence, adverse jury instructions, dismissal of the charges, contempt proceedings, and sanctions. I would certainly argue that sanctions could be financial, that they'd have the ability to do that, and that I believe is persuasive authority. Then looking at 3.220, and again, the state points out or argues that it's a post-conviction remedy, Brady, and this goes to the court's ability to impose sanctions, I believe, and our argument is especially after the Due Process Protections Act. When in 1989, 3.220 was modified to include to adopt Brady. And if you look at the editor's notes from 1989, the last phrase of renumbered subdivision paragraph B2, it's renumbered since then, is added to emphasize that constitutionally required Brady material must be produced regardless of the defendant's election to participate in the discovery process. So they're pointing out, first of all, that it's a pretrial obligation, as Your Honor just mentioned. Now, I think that coupled with now what federal courts nationwide permit trial judges to do in terms of sanctions gives this court authority at this point. And yes, there's no Florida case law as of right now, but
Well, there's Florida case law to the contrary. I mean, I can tell you from this ZA case, appellate courts have held that the trial court has no authority to impose costs in the state attorney's office, even if the state commits a discovery violation.
correct. And the Florida and criminal defense attorneys are interestingly, under the rules of ethics, situated to argue that current case law is unlike, I believe, any other field any other legal field, that current law is unconstitutional. And for that reason, in every death penalty case, we file motions saying the death penalty is unconstitutional. Even though there's case law to the contrary, we acknowledge what the case law is. So acknowledging what Florida case law Your Honor has in front of you, and this is for purposes of preserving it if Your Honor rules against us, that following the Due Process Protections Act, based on the legislator's intent in codifying Brady in 1989, this court does have the authority to sanction. And I'm not sure if those cases are before 2020. I don't have them.
2016 and 2010. But like I said, that's what I was hoping maybe we're asking you whether or not you had something that would be contradictory to that, or give me the assuming I would agree with you that there's been a violation which rises to the level that sanctions are in order, then do I have the authority? You haven't given me any case law to that effect. But again, I'm open to being educated, sir. But you don't have anything for me except for what you told me about, right?
Sure, and that would be our.
Okay.
Now, as to.
Now, what about in terms of the reasons for sanctions? Can we get to that?
Yes, your other question was, inadvertent versus willful.
So let me just tell you from a factual standpoint, okay, is that it has not been proven to me that Mr. Scott found the file in his office. Okay, I am persuaded with McCann's statement, and I find it not logical that the file was actually in Mr. Scott's office. It was in the office of the sheriff's office, and then the question then becomes is, I assume that there have been repeated attempts, Mr. Scott, to look for this file. How is it possible that the sheriffs didn't see that file? Right? It's ridiculous.
Sir, I don't know.
And again, that's one reason I have Mr. Ehrenberg here. This stuff should not happen. This case has been continued twice. I've had to block off time on my docket in May and now. It's incumbent upon prosecutors to be on top of the sheriff's office and other law enforcement agencies that this does not happen. It's ridiculous. It's not only causes problems for the defense. Ms. Keen's waiting her day in court. The victims are waiting for their day in court. I blocked off I blocked off time twice. And you can talk to the line prosecutors in here. I've been continuing cases that would typically not continue. So victims in those cases and defendants in those cases are waiting justice on another time. Because there's been no, for whatever reason, there's been things that have happened in this particular case, Mr. Scott, with Barr initially, and then with the clown sightings file all of a sudden materializing, that have led to me granting continuances, right? And so I'm asking Mr. Amberg, I'm glad you're here. Thank you for being here, sir. But you need to be on top of this one. If you're not, I assume you are. But this can't happen. When this case is set for trial the next time, I can't have this continued again. It's not fair to anyone.
Yes, sir.
You know, and assurances have been made by you, Mr. Scott, in the past that won't happen. Well, it's happened again, right?
Yes, sir.
And that's put the court in a difficult position.
Yes, sir.
And here we are, the motion for sanctions, and we're supposed to be spending today picking a jury. I had 200 people coming into courthouse today to pick a jury on this case. Spend the next 3 or 4 weeks trying this case, and this case needs to get to a jury already.
Yes, sir.
I know, Mr. Rosenfeld, your arguments, I know the state's argument, I've heard it already in the Arthur hearing, right? It needs to get in front of a jury and let the jury decide this case already. And in all fairness to Ms. Keen Warren, in all fairness to the victim's family. So I'm hoping that this doesn't happen again in the future, okay? I've gone off on a little, something I wanted to say later on, but this can't happen again. And the ripple effects are huge in my world, you know, and in the world of victims and defendants. Anyway, Mr. Rosenfeld, what else you want to tell me?
All right, so Your Honor asked, again, I think the second question was willfulness.
Yeah.
And, you know, a point that I think back to 2012 to Judge Peter Evans, a comment he made, that when it comes to whether a prosecutor's willfulness, one thing the court should consider is a pattern, whether it's in a case or other cases. But, you know, when someone continues a certain behavior over and over and over again, and I'm referring to this case right now, you start to wonder, okay, it's not a mistake anymore, it's willful. Now, we've had to, over the past 4 years, since 2018, and I have the pile here, we filed a motion to produce Brady information, 17 specific demands for discovery, 3 motions to compel discovery, 3 motions to compel forensic discovery, 4 motions to compel Brady material, a total of 28 pleadings to get discovery in a case that they worked for 4 years. 4 years prior to indicting Ms. Keen Warren. And on, Ms. Morris throughout has been beyond on top of keeping, exceptional job of keeping track of, discovery that's turned over. And I can't tell you, how many times we'd requested and the state would say, oh, yeah, we have it, and turn it over. How is it in a homicide case? We have to file 28 pleadings to get evidence that's in the state's possession. I mean, that is beyond unacceptable. That is 28, and I don't want to say 28 discovery violations, but in many instances, when it's in their possession and they say, oh, yeah, all right, we're going to turn this over, that's a discovery those are discovery violations. And it's, how can somebody get a fair trial when we're not getting discovery? And, I think that certainly establishes a pattern of willfulness. Now, on each occasion, or on, not each, but on at least 3 occasions I can think of, in response to the state not turning over this discovery, Mr. Scott has made the same statements to us. He said, oh, that's my mistake, I thought I turned it over, or I'm trying my best. One instance recently, and this was, 2 months ago, Ms. Morris, the letter? May. The state received a letter. an anonymous
So
letter.
the motion for sanctions, that you're talking about a lot of other discovery violations. The motion for sanctions deals with your request for $3,300 for the out-of-state subpoenas for the investigating for the trial, the 5 hours investigating, filing pleadings, litigating the issues regarding the clown siding file. Right? That's what you embodied in your motion for sanctions.
But I have to establish willfulness, and I'm establishing willfulness through a pattern of conduct that's happened throughout the case, which, you know, like I said, I believe is one way to establish willfulness.
All right, go ahead.
And you know, again, and I'll say this, Mr. Scott and I have a great relationship outside of court, so I take no joy in making accusations against Mr. Scott. That said, these are things that happened, and these are things that continuously happen, and these are things that show this isn't negligent, it's willful. Again, 2 months ago, a letter, anonymous letter, wasn't turned over, we found out about. The answer we got was, Ms. Morse got was, I thought I turned it over, it's just an evidence. The Ed Bar material. Outside, begging Mr. Lubin, Ms. Morse and I for forgiveness, I would never do this intentionally, comes into court, tells Your Honor about what happened, and then we find out after the fact that wasn't everything that happened. He neglected to tell the court, and we found this out about a week.
I'm aware of that. We had the hearing, right? He didn't relay that information to you, right? I knew that.
You're not aware of everything.
But you made me aware of that issue, that he didn't tell you about his conversations with Ed Barr, right? Didn't we have that discussion months ago?
Sure.
That was one of the reasons I continued the case from May to October, right?
But you didn't hear all of it. We found out more information after the fact that goes to this continued pattern of willful discovery violations. The state neglects to tell the court that day, or us, that prior to Ed Barr coming to Florida and being held in contempt, Detective Paige McCann and Investigator Hoover flew out to Texas to interview him. Something that I still have no idea why that wasn't brought up to us or to the court. Something I'm sure Your Honor would have liked to have heard. The fingerprints, it's in the pleading, I'm not going to rehash that was sent out, that wasn't disclosed to us, same thing, same conversation. I should have told you, I'm so sorry, I would never do that intentionally. How many times does the state have to repeat the same pattern of negligence, gross negligence, and dating back to Judge Evans' comment from 10 years ago, to where suddenly it becomes willful? Now, in establishing a pattern for purposes of willfulness, this exact conduct happened and led to a discovery violation and a continuance in another case recently. And I'm saying that to show that it was not inadvertent, that it was not negligent, that it was willful. In I believe State v. Gibbons, in front of Judge Weiss, 4:30 p.m. on the eve of trial, Mr. Scott contacts the attorney and says, I forgot to tell you that I just found 2 boxes of evidence that were on the top shelf. We found it a few days ago. And that led to, a discovery violation and a continuance. Not to mention Mr. Scott's probably the tallest guy in the office, but again, how are these 2 boxes of evidence being found on the eve of another trial, just like in this case? So it's such gross negligence that it rises to the level of willfulness. Now, Ms. Morse did just find a case to answer your last question about, and I haven't read it, so.
All right.
But, State v. JLP 435 Southern 2nd 392.
Can you say it a little slower?
Sorry, State v. JLP 435 Southern 2nd 392.
All right.
And it says, can fine for contempt for not using due diligence to look for file discovery. In the state, you speak of willfulness. The state's obligation goes behind turning over what's in its file. I mean, that's what Whitley says. They have to seek out this information. And when we repeatedly ask the state for, let's say, stick to the clown file, right? And, you know, as you see, Detective McCann for 4 years refuses to do it, and then miraculously, the day after the motion looks for it. That's the state refusing to, or not doing its due diligence and looking for this discovery. Why is it that in a homicide, the state's finding discovery in other boxes? Why is this coming up in other cases? And I'm glad you asked Mr. Ehrenberg about that, because it's a serious problem. And now, you know, Ms. Morrison and I talked last night about this. What other evidence is in other boxes in this case? When we deposed Mary Lou Doss, you know, I deposed her to get the chain of custody records. She indicated that oftentimes they can't find boxes or evidence, and they look to the box to the left, and they look in the box in the right, often in other cases. That's problematic. That's incredibly problematic. And, you know, we find ourselves in a position now where, you know, do we have to go to PBSO, the state attorney's office, and look in every single box for every witness in this case to see if there's other potentially exculpatory evidence? I mean, it has to stop, and at some point the state has to be accountable, and at some point the state has to be accountable for this, for all these pleadings being filed to get discovery in this case. And you speak about the court's docket, you speak about the victim's family, you speak about you know, Ms. Keen Warren and, you know, her sitting in custody. I mean, not to mention the amount, and this is why I brought up attorney's fees. Your Honor's read my pleadings. Your Honor sees the amount of, you know, work Ms. Morse and I put into these pleadings, whether it's motion to set bond or in this case, all of these contempt proceedings. What about our time? Time away from our other clients, time away from our families. I mean, it's just an utter disregard for Ms. Keen Warren's right to due process, right to a fair trial, and again, this repeated pattern of discovery violations now, I believe, establishes a willful violation.
Is there anything else you wanted to add?
No, Your Honor.
Okay. Mr. Scott, I've read your response. Do you want to add to that?
Nothing to add, Your Honor.
Okay.
I believe my response encapsulates my arguments on this point.
All right. So I'll reserve ruling on that. If you have any other case law, Mr. Rosenfeld, that supports the position that I have the authority to seek the relief that you're asking for, I'd be happy to take a look at that.
Sure, and I think on top of, I mean, other possible remedies, if Your Honor does not believe you can impose financial sanctions, we would ask for remedial, that the court order Mr. Scott to undergo remedial Brady training, discovery training, clearly, whether it's through this or through Your Honor having to spend your time writing an order explaining the rules about listing witnesses previously in this case. There's a clear misunderstanding about the state's Brady obligations, which again is in, you know, its response, how it discusses Brady solely as a post-conviction remedy, which is not the law.
Okay. Thank you, sir. Thank you, Mr. Scott. We're last left with the, well, first of all, before we get to the issue on your renewed request for Ms. Keen Warren's release, the trial. This case needs to get to trial already, and but I'm just not going to set a trial date right now without you telling me, Mr. Rosenfeld, you're ready. So how much time before we come back on the status check for you to shed some light on that? 45 days or so? 60 days? 30 days? I want you to have enough time to follow up on the clown sightings file and let me know.
One moment, Your Honor.
All right, great.
I would say to err on the side of caution, while I'd like to say 30 days, realistically, our investigator having other cases, we still have, Ms. Morris emailed Mr. Scott about 5 depositions for witnesses we still have to do. I would say 60 days just to not come in here and waste the court's time on a unnecessary status check. Obviously, if Your Honor wouldn't mind, if we get it done beforehand, we will contact your.
December 22, okay, guys? Thursday, December 22 for status check?
Ms. Morris, that work for you?
So if you want to come in earlier than that, guys, and both sides tell me you're ready for trial, and I'll set a trial date and block off time. My concern is I block off another 3 or 4 weeks in my calendar, and something else happens.
Yes, sir.
And, I don't want to do that again.
And just for purposes of exhibits, Judge,
The exhibits to what?
the motion for sanctions, I do want to admit the invoices for the subpoenas.
Okay.
And also a
Any
copy.
objections to those invoices, Mr. Scott?
I have no reason to believe that they're not authentic, so no objection.
And I will say I'll provide the court with an accurate number, because one of the,
Accurate number what?
well, there's,
Of this-
one of the invoices has a subpoena for a deposition, so the total number is actually $3,347.50, which is less than,
That's what you put in your paragraph 20 of your request, 3,347.50, right?
yes, and that's for the out-of-state. For the in-state subpoena is $50, not $100, as reflected on one of the invoices, one of the other invoices, in light of the fact that, again, one of them is for a deposition, not trial, and $810. So $860 for our in-state trial subpoenas, and $3,347.50 for our out-of-state domesticated subpoenas. I would also enter into evidence, as Defense Exhibit 2, all of the notices of discovery, demands for discovery, motions to compel that were filed in this case, all of which Mr. Scott obviously has been served with. May I approach the clerk, Your Honor?
Yes. Yeah.
And the only thing I'll put on the record, Judge, is just in reviewing these documents, it would appear that at least 7 of these witnesses are also under state subpoena, so.
So what you've just submitted would be the invoices for the subpoenas. We're dealing with the subpoenas, as well as a variety of motions you all filed regarding discovery, correct?
Yes.
Okay.
And we would also be asking, one thing you didn't address in terms of sanctions is attorney fees.
Okay.
We would also ask for, and, it's obviously hard to calculate how much time is spent on all of these, these consistent pleadings, these most recent pleadings, the sanctions pleadings, but at a rate of $400 per hour. And we would ask that this court impose fees for the investigator to, rush investigate these.
What evidence has been presented to the court about fees today?
I mean, if Your Honor wants to take testimony from me and Ms. Morris.
You got the burden.
Sure. And I will give you a number that's probably 10% of the amount of time we've spent on these pleadings, which would be, let's say, 10 hours, which is, like I said, far less than we actually spent, but just to be as conservative as possible, at a rate of $400 an hour for $4,000. And at this point, we don't know, but whatever fees we have to pay for the investigator to follow up with the investigation on the clown setting file.
Your testimony then is it's 10 hours at $400 an hour, correct?
Yes, $400 an
Do
hour.
you want to ask me any questions in that regard, Mr. Scott?
Yes, Judge, I would ask for what their normal rate of services and what these 10 hours were spent doing. Asked to provide documentation to the court and to the state as to what out of the ordinary other than what we normally do on a day-to-day basis in filing motions and coming into court and preparing for trial, what out of the ordinary was done in particular to this case in this matter that would justify the state being held responsible for attorney's fees? Because up to this point, all time should have been in preparing for trial, which the state has been doing. So what above that would justify the state being responsible for any of the additional work by the attorneys that they're not already being paid for?
Well, that's the purpose of attorney's fees. Generally, you're being compensated for, you were in family law for quite a while, that division.
Oh, yeah, and there's a whole, it's a different animal, and I don't think you've done what you need to be doing, Mr. Roosevelt, to establish attorney's fees, to be frank with you, sir.
Correct, but it's.
All right, I'm just telling you.
No, I understand. It's just, you
gave me your invoices for the subpoenas, all right? So what about the attorney's fees?
And the reason why it's difficult.
I haven't heard an expert testify. I haven't heard of your agreement between you and Mr. Warren. Do you really want to get into that?
No, I would just say that it's a little different.
Maybe you don't want to get into that, Mr. Roosevelt.
No, I recognize that. Without going any further than this last statement, it's, Your Honor, having practiced in criminal defense for quite a while, you're aware that the Florida Supreme Court.
You want to keep your request at $4,000 at the rate of $40 an hour for 10 hours, sir, as it relates to dealing with the clown sightings file? Is that what you want to? Is that what your? Because that's the motion. Your motion deals with the clown sightings file, the issues relating to investigating that, the pleadings relating to that. Your position is that $400 an hour for 10 hours covers that, right?
No, I would say.
Or maybe even according to you, you spend even more than 10 hours on this issue.
Sure, I would say that includes all of the other motions we filed throughout that are necessary to establish a willful violation.
Okay.
So not just the clown setting file.
Okay.
Everything that. But I understand Mr. Scott's objection would be we don't have an expert to.
And Your Honor, I would add that I've turned over to defense counsel the work that state attorneys done, analysts have done in order to expedite and make efficient any follow-up on the clown sighting file. I've reduced their work by probably 90%. So, and I've turned that over to them today.
Okay, all right. Anything else, Mr. Roosevelt?
Nothing further as to sanctions.
All right.
I think bond is the last issue.
Okay.
If I can collect my notes on that.
Sure, yeah.
Judge, on the 22nd, will it be at 9 a.m.?
I'm sorry?
On the 22nd, will it be at 9 a.m.?
Hopefully. Of course, at 8:30, but I don't think it's more than 5 or 10 minutes is needed. I have to put it on my regular 8:30 docket. So, you want Ms. Warren here? Ms. Keen Warren here?
No, if we could not.
So it's just a status check.
Correct.
Okay.
And Your Honor, just to supplement and add one more point to the last argument, that the defense would have to conduct an investigation on these names, whether they were turned over now or 2 years ago, and it's not the state attorney's office responsibility for them to conduct that investigation. We have actually done so for them, but that would not be a sanctionable.
Again, all this may be a moot point anyway. If I don't have the legal authority to tax costs anyway.
Yes, sir.
Okay. All right. Okay. Court will be in recess for 5 minutes.
To order. Court is now back in session.
All right. Everyone have a seat, please.
You want the lawyer to sit, Judge?
Yeah, any chance that we could have Ms. Morris and Ms. McRoberts do this? No? I'm a little tired of looking at you guys, but it's okay. All right, maybe next time. All right. Farmer consideration, go ahead, Mr. Rosenfeld.
All right, so the state mentions that there's been no change of circumstances. First of all, that's not the standard for modification, that's standard for revocation. We have to have a good faith basis for coming forward before the court, which clearly we do. And even if that was the standard, there have been change of circumstances as I outlined in the motion. The two things, as Detective McCann pointed out in her initial deposition, that led to her establishing probable cause that changed from their initial investigation until now, were that 6 to 8 inch fiber that miraculously appeared on this balloon ribbon, and DNA strands of hair found in the white LeBaron.
Is that new since I made my ruling last year on the Arthur hearing?
That those are the two bases? No, but information we have learned since the Arthur hearing about as it pertains to the fiber and the DNA is new. Specifically, we deposed Detective Michael Harrison and Latent Examiner Jay Mullins. Detective Michael Harrison was the lead crime scene investigator who packaged the balloons. And Latent Examiner Jay Mullins, along with Harrison, were the people who were the first to process the balloons at PBSO. So they went into evidence, they got it, they processed it, the balloons and the ribbons. That included doing latent print analysis in fumigation chambers. I mean, that really involved moving these balloons and these ribbons around. They both testified, and we'll start with Detective Harrison. And as I put a portion of the report in the record in the second motion to compel, indicated that in no uncertain terms there was no fiber. He looked at it for trace evidence. Before packaging it, there was not a 6 to 8 inch fiber on this balloon ribbon. Mullins, no recollection of a 6 to 8 inch fiber on this balloon ribbon or this balloon, which again was being processed in every way imaginable. Putting something in a fumigation chamber and moving it around is significant. So at the last hearing, one of the two things that Detective McCann had stated were the basis for this subsequent arrest we now have new information on, which is it wasn't there. And that goes to this contamination issue that happened between 1990 and 2013 when Celinda Sowards miraculously discovered this fiber on a balloon ribbon. So that's the first piece of evidence Your Honor did not consider. Secondly, the DNA from the 2 strands of hair found in a white LeBaron. The state we have since deposed Brandy Christian from the FBI, and she has essentially confirmed everything that we brought up. We have additional evidentiary support now for the statements we were making at the Arthur hearing. First, regarding the root, she acknowledged that in her report. She said, Ms. Keen Warren cannot be excluded. There was also a male, and she did not, and as our expert said, and any other expert would say, indicate in her report that the male was the major contributor of a root that was cleaned. That should be a single source. You pull a hair out, you clean it, there should be one person's DNA on it. So that, was since confirmed by the FBI. She also confirmed that she has no idea when, how this hair got in the car, if she was even in the car. The state also has since deposed our DNA expert, geneticist, PhD, Max Norradine, and Your Honor, in determining bond, whether it's an Arthur hearing or after, can also consider our theory of defense. The case law is clear on that. You're well aware of that. And Dr. Norradine found both to be inconclusive. He also pointed out one thing that I did not mention, or it did not dawn on me at the Arthur hearing, and did not ask about, which is the second hair, that's 39-2, the one where 1 in 25 people have the same, U.S. Caucasians have the same DNA. I did not bring up, and I learned from my expert subsequent to that the FBI also found Marlene Warren to be inconclusive. So they can't exclude her as the source of that hair in the car. That's how poor and degraded this sample is. So all additional information, and again, our DNA expert, as Mr. Scott learned 2 weeks ago, has deemed both inconclusive. So that's additional information Your Honor did not have at the time of the hearing. The state goes into, in their motion, information about fibers and comparisons and, the same thing they've been talking about since day one. Additional information. We learned from Joshua Friedman from the FBI, their trace evidence lab, that the 3 pairs of shoes were all packaged together, which baffles me. I mean, that wouldn't be done now by PBSO. And obviously an argument that bad practice back then is justifiable, now that we know now how evidence should be packaged. Took 3 pairs of shoes from her closet and threw them all into a bag. There's no indication or way of establishing what shoes these red carpet fibers were from, and he said, which we did indicate at the last hearing, that they could have come from God knows how many carpets or whatnot around the world. There's no way of determining that. Also, since the last hearing, delving deeper into, in preparation for Joshua Friedman's deposition, and spending more time than I could have ever imagined comparing numbers from PBSO, the FBI at 2 different times, and PBSO again, with numbering systems changing over the years, that the state makes allegations about these acrylic yellow-orange fibers found on clothes and in Ms. Keen Warren's apartment. As it turns out, nothing on her clothes matched this wig that they purchased from Spotlight, from the costume store. One fiber in her house showed similar characteristics. So, I'm not going to say the state made a misrepresentation when it said that. I think it was early on in discovery. But, having, again, done quite a bit more work, both sides, and deposed Joshua Friedman in 2 days, learned that this one fiber was found in debris. There is no indication in any report where this debris is from in her house. There's not a single photo of this debris, and Sergeant Free is now deceased, and the only other person who has any information about where this debris came from, and it's kind of bizarre that that's the one thing that's not, they don't indicate anywhere where it's from, is now legally incompetent to testify. So that's the only, there's not acrylic fibers, which is the basis for the search warrant, all over clothes that matched. One fiber in debris that is consistent with a wig that the witnesses said was not, or at least 2 of the witnesses said in 1991 was not the right wig. I think in terms of, I can just ask Ms. Morris if there's any other new evidence.
All right,
that
all right.
So I guess the last thing, new evidence. The state pointed out that, or a few things that, or as we all know now, the state sent out evidence for fingerprint testing. And the state pointed out in one of its motions that we didn't have to depose this person. It was trivial, his findings. They also indicated that they sent it out because of more advanced testing. This evidence initially showed back in the day when the testing, I guess, wasn't as good as far as the state's arguing, and Ms. Keen Warren's prints were not on this evidence. Now, with more advanced testing, her prints are still not on this evidence. Since the Arthur hearing, they also sent out evidence, they sent out these balloons to compare to Ed Barr, who clearly is someone they're still investigating as a suspect, and compared his prints to the balloons. And the last thing I'll say is the state points out again in its motion about several witnesses from the clown sighting file, or pardon me, from, Spotlight, identifying Ms. Keen Warren. There was never actually a positive identification. It was looks most like for one of them, and the second one.
Scott, what about that? You do put that in there, right? That they identified her?
Yes.
Did they identify her?
Yes, Judge.
How did they identify her?
There are two photo lineups, and the way they did photo lineups previously were to have a manila folder, and then they open up the manila folder, take a look at 6 photographs. On the back of the photograph of Ms. Keen Warren that was viewed by Dinah Rosales, it is marked as she selected Ms. Keen Warren. She signed her name to the back, Ms. Dinah Rosales did, and she's also testified to that in multiple statements and deposition. I believe in deposition she also testified to that. And then there was a second witness, Ms. Debbie Offord. I believe she was Debbie Lee back then, Debbie Lee Offord, who has also maintained in deposition that she selected the person who she believed to be entering the store and purchasing the clown costume. And we also have Ms. Offord's, a folder that Ms. Offord looked at where she initialed Ms. Keen's photograph, and then she also initialed one of the other photographs. So she selected between one of the two, but I believe in deposition she maintained that Ms. Keen looked most like the person who walked in. So that's actual physical evidence. It's a photographic lineup signed on the back. So based on not only their testimony and their previous statements, and I think it's important to note that Ms. Rosales dated the identification of Ms. Keen, I want to say it's 5/27 of 90. So the homicide occurs on 5/26 of 90. This is the very next day, and I want to say that Ms. Offord looked at her photographic lineup on 5/30 of 90. So within 4 days, both of these ladies who worked at the Spotlight costumer were able to not only describe a person that appeared to be consistent with Ms. Keen Warren, but also looked at photographic lineups to which they signed their name to. That's my mode of identification. And these two individuals, Ms. Offord and Ms. Rosales, have both been deposed by defense counsel. I don't believe they've ever testified at a hearing before Your Honor, but have maintained their identification of Ms. Keen Warren as the person who bought the clown costume.
Their quotes were, one was, it was a photo array, and as Your Honor.
I remember we dealt with this last year. Wasn't there some issue about that, Mr. Rosenthal?
It was, one said, and obviously photo arrays are I've shown to be unreliable, but we'll get to that in future pleading. Did not say that's her. She said it looks most like her, of the 6 people, and the other one said looks similar, and then also identified somebody else. We also learned since that last hearing, a month ago, due to a late disclosed witness that the state found in Tim Valentine's folder, and then we deposed a woman named Linda Napoleon, who was just recently disclosed, and she said between her initial identification, she was the manager at Spotlight, between the initial identification and when they went back in 1991, they would consistently gossip about, what happened to Ms. Keen Warren, and they actually had not one newspaper article, but they would collect the articles in the store with photos of Ms. Keen Warren, which.
Okay. All right,
So-
go finish up your argument, sir.
And, yeah, and the last thing the state represents in here that, about, Publix and the two witnesses there. One, Ms. DeFrancesco is sadly passed away, but she could not identify Ms. Keen Warren, like, at all, when shown a lineup. The second was, Ms. Albro, who, you know, is all over the place now, but in her,
The lady that testified on the Zoom?
Correct.
but in her 1991 sworn statement, said on 3 occasions that she thought it was a boy, and in 1990, not a woman, a boy, in 1990, when shown photos, could not identify Ms. Keen Warren. So,
And again, with respect to that, she, you know, as Your Honor heard, she saw her from the back. She was really more important to the identification of the balloons and/or the flower arrangement, really than to the face of the individual.
Anything else, Mr. Rosenfeld?
as to new evidence, I would, that's the new evidence, but Ms. Keen Warren can still live with, pardon me, Ms. Morse did speak with, Ms. Keen Warren's son. She could still live there on house arrest, the same conditions we discussed before. No firearms in the house, obviously, you know, GPS monitor. You know, she's been in for over 5 years. You know, you've seen the number of discovery issues that have come up. She's actually been in protective custody for 5 years, I believe 23 hours a day in a box, 1 hour out, solely because of her concern of a jailhouse snitch making up a story about her. So for 5 years, she's essentially been in what's as close to solitary as possible. The state, without rehashing, willful, negligent, whatever we want to say, has turned over discovery over and over and over again, and it has delayed these proceedings. And, you know, we would argue that her mother is 83 years old, hasn't seen her in 5 years. She would like to at least see her mom, get out and see her mom. You know, this pretrial delay is excessive, and, you know, a lot of the pretrial delay, aside from the discovery issues, you know, was caused by the state waiting for 23 years to reopen this cold case. And that's, you know, that's not on her. And a lot of the problems that have come from that, you know, due process issues, deceased witnesses, incompetent witnesses, you know, have come from that and have created serious obstacles, and the state acknowledges, in preparation for trial.
Okay. Anything else?
No, Judge.
All right, Mr. Scott?
Just brief response, Judge. You know, with respect to the 27-year delay in filing the case, I mean, I can't speak to that. When I started handling the case, when I handled the case, I will tell you, and I told Your Honor in previous pleadings, that there were no depositions taken in this case by defense for 631 days following the indictment of Ms. Keen Warren. That's certainly not something that the state could do. They just didn't do any depositions. Whether they were doing something else in the meantime, I don't know. And then unfortunately, we did have about an 18-month COVID-19 delay where we had travel issues and sickness issues that are beyond anybody's control. So, and then just with respect to, I know Counsel has referenced the numerous discovery demands, and I would just say that most of those demands, you know, could be handled with a phone call, or, you know, I mean, they don't need to be filed. If you call me, tell me you need something, there's no need to file a motion. So, while I understand, you know, Counsel wants to make his record and put the demands in the court file, again, most of those could have been handled with a phone call. So just talking about just briefly about the evidentiary issues that Counsel mentioned that are new. With respect to the fiber that was located on the balloon string, Ms. Sowers did testify that she located the fiber in 2014. I believe I made one sentence of mention of that fiber in my previous motion. I did not rely heavily on it. With respect to the minor contributor to the profile in the hair, I believe that issue was explored at the prior bond hearing. Ms. Keen Warren is the source of the minor contributor to the hair. Both the state's expert and the defense expert both agreed to that she's the source of the minor contributor. And neither expert can exclude Ms. Keen Warren from being in that vehicle. The defense expert can't say how the DNA got to where it is. They can only testify to the percentages. So that's really not an issue in dispute that she is a contributor to a minor profile. As counsel just stated with respect to Ms. Linda Napoleon, this was Ms. Linda Napoleon, and the newspaper articles that were at the Spotlight Costumer were published months after the initial ID. So it cannot be said that those newspaper articles in any way affected the ID by Ms. Rosales and Ms. Offord. I believe Ms. Napoleon did testify that Ms. Rosales, when looking at the newspaper article almost a year later, was definite that the person pictured in the article, which was Ms. Keen Warren, was the person who came in. But again, that's all post initial identification of the photo lineups. With respect to Josh Friedman, yes, Mr. Friedman did testify that 3 pairs of shoes were packaged together, and they all came from the defendant's apartment. However, I would point out that they all came from the defendant's apartment. They all came from the same closet in the defendant's carpet. So the fact that they're packaged together and that the nylon, the red maroon carpet fiber could have come from any one of the shoes is frankly irrelevant, because they all came from the same place and they're packaged together, and there was no maroon carpet in her home. With respect to the yellow mod acrylic fibers not being exactly matched to the wig. Again, this was a sample wig that was bought, and it was bought for the purpose of comparing the generalities and the consistencies of the yellow mod acrylic fibers. The state never alleged that those fibers came from that wig. That was just an exemplar wig that was purchased. It is important, though, that Dwayne Kelly, in his perpetuation, was asked about any visual observations that he made when he was present for the search warrant of the defendant's home, along with Detective Free and I believe Detective Williams, and also either James Storms or Lou Sessa. One of those 2 gentlemen were there, but Dwayne Kelly testified under oath that he made visual observations after being called by a lieutenant, whose name I cannot recall, to look into the defendant's closet, and on her clothing he did make visual observations of these fibers. So that is something that Dwayne Kelly did testify to and would provide corroboration for the presence of those fibers. And then finally, with respect to the balloons, the state did state that the new fingerprint evidence was not significant because all it did was reconfirm what the evidence was back when they originally ran the balloons. I did not state in my response that the report was trivial because it was not important. It was simply that it just confirmed what we already knew, and that Ms. Keen Warren's prints were not found in the balloon back then. They weren't found now, and neither was Mr. Barr. So my point with respect to the balloon is that nothing changed. There was no significant shift. So just those few points, Judge. I would rely on everything that I've written on every other point, as well as everything that Your Honor already heard at the Arthur hearing and that I prepared in my response to the defendant's motion for bond. I don't believe that there's been a significant change in circumstances. She is still charged with first-degree murder with a firearm, and all of the prior points that defense has argued have been previously argued, so I would ask Your Honor not to change the previous ruling.
I can just briefly reply, Judge?
All right.
Mr. Scotch has indicated that Detective Kelly testified under oath as to fibers he observed on clothing in Ms. Keen Warren's house. As it turns out, none of those showed similar characteristics to the fibers from this wig that didn't match. Again, one fiber matched according to the FBI. That was from debris. And regarding the fingerprint testing, again, it was sent out for more advanced testing, so now we know with even more advanced testing, her prints were not on it. And last, the state again spoke to pretrial delay. Again, Ms. Morrison and I were on the case two months before the first deposition, and when the state filed its initial exhibit list, which was 60 days after Ms. Keen Warren was indicted, not 15 per believe the rule says 15. There are, and I have a copy of this for you highlighted. There are 37 witnesses on there that either have no addresses, have to be provided, have care of the state attorney, if I may approach. Or-
You made these arguments before, I know what you're talking about.
All right, and, which obviously made it very difficult to schedule depositions in a death penalty case. If there's one person I would rely on, one defense attorney in this county, state, or even country who, by reputation and his 47 years of experience, if there's any delay, it's not caused by lack of due diligence, it's caused by thorough preparation. And you know Mr. Lubin, as well as everyone else in our community, has the reputation for being the hardest working person I've met, the most diligent person I've met. So, again, any delay, I can guarantee, was Mr. Lubin working up that case, not sitting on a case.
All right, thank you, Mr. Rosenfeld, thank you, Mr. Scott.
Thank you, Judge.
And I got a ruling out as well on the bond, revisiting the bond motion, okay?
Thank you, Judge.
I'll see you guys December 22.
Great, thank you very much, Ron.
We'll be in recess.